This week's podcast is sponsored by Montclair State University. Located just 12 miles from New York City, Montclair State University is a public research university that's helping students get from where they are now to where they want to be. Nationally ranked for social mobility and Washington Monthly's #1 public institution in New Jersey, Montclair is the state's premier public service institution. Learn more about what makes Montclair a university on the rise at montclair.edu. Hello, and welcome to the Washington Monthly. I'm your host, Ann Kim.
And I'm your co-host, Garrett Epps.
In this episode, the Supreme Court's shocking decision to greenlight racial profiling.
I'm standing at a street corner. Let's say I'm wearing, jeans and a work shirt. I have, a lunch bag. And I'm standing next to a brown-skinned, Spanish-speaking individual dressed identically with the same lunch bag. He could be stopped under these criteria. I would not be. And the only differentiation is race.
Garrett speaks with Washington Monthly contributing writer Peter Shane. Peter is Distinguished Scholar in Residence at the New York University School of Law.
So hi there, folks who don't know Peter. Peter is the Monthly's go-to guy for questions about most of the hot topics in Trump's second term: executive power, separation of powers. Before the 2024 election, he hosted a hugely important podcast called Project 2025 Revealed, which again had a great deal to do with executive authority, and I really wish people had paid more attention to it. But early this week, Peter, you posted on our website a very powerful piece entitled "A Blinkered Supreme Court Blocks Relief from Racial Profiling." It's a scathing discussion about the civil liberties aspect of a decision the court announced on September 8th. That case was called Vasquez-Perdomo, and in your piece, I almost got the feeling that you had some criticisms of the court. Exactly what was this decision, and did the court actually say anything?
The court, as a court, did not speak. There was no majority opinion for however many justices supported what the court did. And just, I suppose we should say for the record, what the court did was it stayed injunctive relief that had been granted by a trial court in California, United States District Court for the Central District of California, against basically the targeting practices of the ICE agents who were stopping for interrogation people who met 4 criteria, which enjoy a certain correlation problem. So one of was whether the person appeared to be from Mexico or Central America. The second is whether the person was speaking Spanish or English with a Spanish accent, with a Hispanic accent. The third was whether they were in a location where it was suspected that undocumented immigrants might be looking for work. And fourth is whether they themselves appeared to be engaged in a low-wage occupation. And I suppose that the paradigm that people have in mind that think that this was a rational set of criteria is that there's a particular parking lot of a particular hardware outlet that is known to be a sort of site for this. But it was clear, this could be a bus stop. There's no explicit geographic constraint on the kind of geographic location where people could be targeted. So the lower court was persuaded that these criteria were casting a net, sort of non-discriminating in a sense, that, the only kind of differentiation that would cause an ICE agent to target someone, let's say at a bus stop, maybe they had a lunch pail for their low-income job, whatever. The only difference, the only thing that would really be singling that person out for a stop would be their race or ethnicity. The correlation between looking like you're from Mexico or Central America and speaking Spanish or English in an accented way, those really don't seem like independent variables. And we're talking about a district in California where the court found that 47% of the residents of the district self-identify as Chicano or Hispanic, or Latino of some sort. So this was a net that was going to catch a lot of people who were not appropriately targets. And the court basically, issued an injunction that said, ICE, you can continue to target people. You cannot use these 4 criteria, however, as your exclusive net. There has to be something more particularized to decide to go after a specific individual. The government appealed that to the Ninth Circuit. They asked for a stay of the order. The Ninth Circuit did not stay the injunction. So the Trump administration followed its now not so unusual procedure of going to the Supreme Court using their so-called emergency docket. Justice Kavanaugh now wants to give it a more euphemistic name. I think he wants to call it the interim docket. Will Bode famously called it the shadow docket. And then, our friend Steve Vladeck wrote a book with that title. But they asked the court to stop to withdraw the injunction or to stay the injunction while the case was being heard on its merits. And the Supreme Court is not required, it's not their practice to issue a court opinion when they act on these applications. There is some briefing, but it's not the kind of briefing that would happen in a full-blown argument session. They don't hear oral argument in the same way. The issues are just not vetted with the same kinds of care that you would associate with the cases that they're going to start hearing the first Monday in October. What happens is you get a decision, which is, yes, the application for the stay is granted or the application is denied. And whether anything is said at all is completely discretionary with individual justices. In this case, there was, as we've seen in a lot of cases with civil liberties or separation of powers implications from the Trump administration, there's often a dissent written by one of the sort of liberal justices. Sotomayor is often the voice in these civil rights cases, but it could be Kagan, it could be Justice Jackson. What's unusual in this particular instance, and I guess this counts as a kind of public service, is that Justice Kavanaugh wrote an opinion concurring in the denial of the application. Strictly speaking, we don't know whether all the other 5 conservatives voted for the application. It only takes 5 votes. There might have been another dissenter in there, just decided not to join the dissent. We don't know. And we don't know what the other 5 justices in the 6 justice supermajority were thinking. But we do know what Justice Kavanaugh is thinking. And I was, so bold in the piece as to imagine that what he was articulating as concerns were not idiosyncratic to him alone, that they were.
Let me ask you about that opinion by Justice Kavanaugh, because he makes some fairly interesting factual statements. And, you can take his opinion and compare those statements to the actual record that's even available on the court's own website. And I want to read something from the Ninth Circuit opinion. This is the Ninth Circuit discussing why it is affirming the lower court's injunction, why it is telling ICE, stop doing this. Plaintiff Jason Brian Gavidia is a U.S. citizen born and raised in East Los Angeles. He identifies as Latino. On the afternoon of June 12th, he stepped onto the sidewalk outside of a tow yard in Montebello, California, where he saw agents carrying handguns and military-style rifles. One agent ordered him to stop right there. Another ran toward him. The agents repeatedly asked Gavidia whether he was an American. They repeatedly ignored his answer. I am an American. The agents asked Gavidia what hospital he was born in. He explained he did not know which hospital. The agents forcefully pushed him back against the metal gate, put his hands behind his back, and twisted his arm. An agent said again, what hospital were you born in? He again explained he did not know, but answered East Los Angeles. He then told the agents he could show them his real ID. The agents took his ID and his phone, kept his phone for 20 minutes, and never returned his real ID. Now, does that match the description that Justice Kavanaugh gives of what's going on the streets of Los Angeles?
It does not. The way this comes up, and it's relevant in 2 ways, I think, Garrett. As you know, one of the things that the court is supposed to consider in granting an injunction, or in the case of these applications, staying the injunction, is the balance of equities, the interests that the government has in avoiding the injunction and the interests that the individuals have in maintaining the restraint on the government. And the Kavanaugh opinion really minimizes the interests of the individuals. He says, as far as undocumented persons are concerned, their interests are minimal, if any, in resisting interrogation. As for citizens, the only thing that they're risking is what he describes as a brief interrogation. So that makes it sound, and I think you and I have joked about this, as if there's this kind of polite, "Excuse me, sir, might I interrupt your stroll down the street for just a moment while I inquire into your citizenship status?" And that picture, the record shows, is completely unrealistic. But Kavanaugh makes a move, and it's not an unprecedented move. It's not unprecedented for this court, but there are yet more historic precedents that is kind of scary, which is insofar as Justice Kavanaugh recognizes that this is not exactly an accurate description of the typical encounter. He says, okay, there are allegations here that force is involved, but that issue is technically not before us. And that, I want to say, so we could think back on a case, for example, you remember the case about the football coach whose First Amendment right to pray on the field after a game was upheld by the court. Yeah. In that case, I want to say, and I'm it's already been a long week and it's only Tuesday. I can't think of a good synonym for lie. So I'll just say that the majority opinion lies about the record. They describe this coach as if he were sort of engaged in some private act where he was just quietly and without attempting to involve anybody else, just having this inconspicuous prayer, when in fact he was galvanizing a group session to worship Christ on the football field. So this technically not at issue is not quite a lie in that way, but it is pernicious. And the most famous example that I could think of, and I mentioned this in the article, and I know Justice Roberts takes great umbrage when this is mentioned in the same breath as any discussion of his court. What came to my mind immediately was Korematsu, where Fred Korematsu was arrested, charged with violating what was technically an exclusion order in California that was issued as part of the campaign to intern Japanese American citizens during World War II. And the orders started not with, thou shalt be interned, but rather we're creating an exclusion zone. You have to remain outside. And the only place you could go outside was the transportation center to take you to the internment camp. So he's challenging his conviction, and he's challenged this on the basis that this is, racially bigoted, unconstitutional violation of his rights to due process under the Fifth Amendment. And the court says, the majority, I should say, says, we're being tasked here as if what we're being asked to do is to sign off on some program of citizenship, the internment of American citizens. That's not our issue. Our issue is the validity of this curfew, and that's the only issue technically before us. Technically, okay, but it blinks reality in just a completely institutionally irresponsible way, not to recognize or acknowledge the fact-finding that's happened in the courts below, fact-finding to which the Supreme Court is supposed to be deferential. And I'll just say it's shocking. Can I just say one thing? As you know, Garrett, unfortunately, I don't typically write quickly. It takes me a long time often to iron out a piece the way I like it. And I know you and our other editor friends at the Monthly would like me to write a little more quickly. But I was so angry the Monday of that opinion was written, that night it had to be said. I was just infuriated.
Well, Peter, I without speaking to that, I will say that after I got your email, I had to foam down the computer to stop the smoking. And we were very glad to be able to publish it. But, in addition to this discussion about the record, Kavanaugh does something else that potentially is it seems to me, dangerous for other cases of this sort, and that is to apply a sort of unusual approach to what we lawyers call standing. And, for those who are listening who are not lawyers, standing means that there's something that's happened to you that gives you the right to come in and bring a lawsuit. Because, the fact that I happen to disapprove of the new ballroom in the White House doesn't mean I have the right to sue. I'd have to show that somehow it's injuring me. And there's an absolutely fascinating discussion of standing in this case, and you take it on pretty head on in your piece. Could you tell us a little bit about that?
What you say is correct, both about the importance of standing and Kavanaugh's unusual treatment of it. it's not just that you have to show that you've been injured, although that's obviously key. And the ballroom example is perfect. I mean, what the court would say is maybe you're injured as a taxpayer, although Trump insists that no public funds are being used. That injury is not different from anybody else who's kind of offended by the ballroom. So that's not an individuated injury enough to have standing. But the other thing you have to show is that the relief you're asking for would actually make you better off. And what Justice Kavanaugh says is that this case is like an earlier case in which the Supreme Court denied standing partly to an individual to challenge the way the Los Angeles police in that case were encountering potential suspects. And the case is called City of Los Angeles versus Lyons. And it involved, a motorist, Adolph Lyons, who was stopped by the police, told to get out of his car. He didn't resist. The record indicates he didn't resist. But he was subjected to a chokehold that rendered him unconscious and damaged his larynx. And he sued. He sued as an individual on the ground that he was entitled to damages for the injury he sustained. But he also asked for an injunction against future police misconduct using a chokehold. And the court said, well, you can sue for damages. If you prove your case, the damages will repair the injury you have suffered. But you're not entitled to, you don't have standing to bring the case for a future injunction unless you can show that you are likely to be subject or potentially subject to a chokehold again that this injunction would protect you from. And of course, he couldn't show that. So they said no standing for the injunction. And if you think about that case in comparison to this case, and you take seriously the idea that people are being injured in an important unconstitutional way, or at least potentially, that's what's going on. What immediately occurred to me is that's a good precedent for dismissing standing here. This is almost conclusive as to why this is a different case. Why do I say that? So the plaintiffs in this case, there are 5 individuals and a number of group organizations who together, even if they were the only parties in the case, probably bring hundreds of potential targets of ICE enforcement into the court. And they were actually asking for certification as a class action, which would have potentially reached a great many more people. The lower courts hadn't dealt yet with the certification question. So we're not concerned in this case about what's going to happen to a single individual who would have to be as lucky as the lottery winner who got 2 tickets or as unlucky as the person struck by lightning twice. We're talking about a group of people, all of whom pretty much share exactly the target criteria that ICE is going after. So we're talking about a broader universe. And by the time, what the Supreme Court knew, by the time the Lyons case was argued, is that the LA Police Department had already adopted an explicit policy against chokeholds. Indeed, there are 2 kinds of chokeholds. One of them they barred completely. The other, they said, could only be used in a circumstance in which the police would be justified in using potentially lethal force. So the court, if you had a justice looking at the world as it actually is, back when the Lyons case was argued, that justice might have said, look, not only does Mr. Lyons have to be like the unluckiest person in the world to get choke-held twice, but given the background policy context, there's every reason to think that what he's asking for, he's getting voluntarily from the department already, which is a promise not to do this again. In this case, Secretary Noem of the Department of Homeland Security she's called the district judge an idiot. She and ICE executives in Los Angeles have doubled down on their right to do what they're doing. I think one of them is quoted as saying, we're going to go faster and harder after these people. Noem said, we're not changing anything. So to the extent that the force issue might not technically be in front of the court, there is no reason to think that the agency is at all chastened by its repeated mistakes in terms of who it's targeting and how they're treating people. In fact, as is often said of this administration, cruelty seems to be the point, not the misfortune.
Well, you also talk about the core of what has happened in this case, which is from now on until there is a resolution on the merits, ICE can go around the streets of this district and stop people, shake them down in the way we described, purely on the basis of their race, their appearance, clothing, the way they talk, and maybe their vicinity to low-wage work. If those are the criteria that can be used to create, the opportunity for a search or detention, that's a real change from what this court has claimed to be a bedrock principle of constitutional law. And you know what I'm talking about. Do you want to discuss this at all? Yeah.
So this is a debate that the conservative majority has had with the dissenters in a lot of cases. Of course, the one that comes most recently to mind is Students for Fair Admissions versus Harvard, the affirmative action case. But the case that I don't walk around life day by day as an angry person. There are some cases that really get to me. And a case that really got to me from some years ago is called Parents Involved versus the Seattle School Board. And it's a case in which the Supreme Court was asked to review the constitutionality of voluntary affirmative action plans or student assignment plans in Seattle and Louisville, Kentucky, that were intended in Seattle's case to maintain a reasonable likelihood of racially integrated school experiences for, I think there may have only been, I don't remember if it was K to 12 or just high school kids. And in Louisville, they were getting out from under a court decree that had ended segregation, and they liked having desegregated schools and didn't want immediately to revert to a plan where, Black kids and white kids would be going to racially identifiable schools. And neither of these plans was particularly aggressive in the use of race. It was just basically, if a child wanted to transfer from their neighborhood school to another school, then the school authorities would ask, how was the school to which they wanted to transfer already a racially identifiable school? And if it was, would this make the problem yet more conspicuous? And if so, the transfer would be stopped. That's all that was at stake. The dissent in that case said, this is really not burdening anybody. This is a commendable educational policy. We should be applauding this. And Chief Justice Roberts, writing for the majority, said no, that there was no interest at stake adequate to support what the school districts were doing. And he said, the way to end racial discrimination is to stop discriminating by race. And that quote, which sort of captures this formalistic view of what it takes to create racial equality. And we saw this resurface in the Harvard and the higher education cases as well. So the court seems really, or the majority seems really wedded to that idea. If race is being used to provide uplift, even in a relatively non-zero sum kind of situation like Seattle and Kentucky. But here, where again, if I am standing, I'm standing at a street corner, let's say I'm wearing jeans and a work shirt, I have, a lunch bag. So it looks like I'm not going to the Duquesne Club in Pittsburgh for my next business meeting. And I'm standing next to a brown-skinned, Spanish-speaking individual dressed identically with the same lunch bag. He could be stopped under these criteria. I would not be. And the only differentiation is race. What happened to the way to stop racial discrimination is to stop discriminating by race. Suddenly we don't care because the people who are targeted are people whose interests we just don't value. And that's a rhetorical question, I guess. And the other thing to be said that the court is also not acknowledging is how stigmatic this is in terms of how Latino citizens of the United States and the thousands, if not millions, of Spanish surnamed individuals who are legally documented in the United States. But let's just think about the millions of Spanish surnamed citizens of the United States who live in California. Now it's kind of okay in the court's view, not just for ICE, but for anybody walking around to say, it's reasonable for me to suspect that the person walking across the street is actually an illegal, in quotes. This is just an intolerably demeaning way of looking at one another that the court is implicitly sanctioning. And I would like to have thought it was un-American.
Well, apparently not. And maybe on that note, that's fairly somber note, we can stop here and just say that what is happening in immigration, it seems to me, is really eroding the kind of egalitarian foundations of a democratic republic, to the extent that citizenship is now something that is in doubt for millions of people, that the government can simply say, we think people like you aren't citizens, so we're going to start shaking you down. We're living in a very different country than we thought that we were living in. And, it's something that people should be outraged about. Do we have any hope that the lower courts will put this right? After all, we haven't really had the trial on the merits. We haven't had the full opinion from the Ninth Circuit. Or is the Supreme Court now in this role of goalie, of the administration's goalie that will never let a goal be scored? Do you have a view on that, or are we just, in the veil of ignorance?
Well, I would like not to be 100% cynical in my expectations for the court, but I think the most generous reading of what they're doing. And again, we don't know what the other five justices might have be concerned about standing. Maybe they bought into Justice Kavanaugh's view that, well, the criteria is sort of reasonable, notwithstanding the wider net that's really being cast. We don't know. But it may also be that the majority in the court has an anxiety, not an unfounded anxiety, that when push comes to shove, if they really tell the Trump administration in terms that are not easily circumvented, thou shalt not do the following, that they'll be ignored. And it may be that they worry about that and they're concerned that that will hurt their legitimacy as a court. And if that is what they're thinking, that might help explain what seems to be their determination not to have that confrontation or to postpone it as long as possible. And an example that I think I know is close to your heart involves birthright citizenship. Here we have something that the Trump administration is trying to accomplish that, let's just say, is flat out unconstitutional. And all but a very few people know it. I honestly believe there is no chance they can win on that issue in the Supreme Court. And yet the court, given the opportunity to address that issue, instead said, well, let's write something about universal injunctions instead. For some reason, the entire Biden administration went by without, the Supreme Court turning its anxiety about universal injunctions against the Biden administration into law. They just let those stand. But now, they said what they said. I'm not sure it's wrong. And I'm not sure how consequential it is. But it's just what's so conspicuous about the case is it just puts off reckoning with the thing they're going to have to reckon with, which is birthright citizenship. And so I don't know. I mean, this, again, the majority on the merits may think something like what Justice Kavanaugh said is actually defensible, or they may be postponing this. The lower court, I think, now has a much clearer understanding of the kind of record that might shame the court into taking these claims seriously. Maybe the complaint is going to be amended to sound more like something that the court could not ignore. That's possible. But, this is going to take time. And meanwhile, the scenario that you've described for the streets of Los Angeles will continue to exist.
Well, on that note, we should probably let you get back to your occupations. But I do want to tell our readers that back in the day, when I was the star sports correspondent covering the volleyball team for the Harvard Crimson, Peter, even though he looks much younger than I, was my editor. And my prose was tremendously improved. Unlike yourself, who write deliberately and calmly, I pretty much put my stuff out there as fast as I can cut the words out of magazines and post them on a brown paper bag. But anytime that I have been able to persuade you to edit me, it has improved my work. And I want to thank you. And I want to thank you for taking the time to be on the Washington Monthly podcast. Have you got any final words for our depressed viewers?
Well, I want to say back at you in terms of, all that your editing has done for my work over these decades that we have known one another. And I think we should correct the historical record. At the time you allowed me into membership on the Harvard Crimson, you were president of that organization, which is still arguably the best daily journalism in Cambridge, Massachusetts. I think, we could both be very proud of that. But I would say to listeners who are concerned about what's going on, litigation against the Trump administration is proving to be critically important. Is it going to stop everything that on its merits ought to be stopped? No. But it's very important that it be continued, that it be supported, that people try to inform themselves about what's going on. The zone is being flooded. As an editor of the kind of book that excerpts these decisions to try to teach students, my zone is being flooded now with judicial opinions that are very hard to edit. But I don't think, we shouldn't despair. This is an important form of standing up for the rule of law. And, we just have to keep on keeping on.
You heard the man, folks. The zone's being flooded. Grab you a bucket and bail. And on that
well
note,
played.
Peter, thank you for coming on. And we hope we'll have you on again soon.
Great to be with you.
This week's podcast is sponsored by Montclair State University. Located just 12 miles from New York City, Montclair State University is a public research university that's helping students get from where they are now to where they want to be. Nationally ranked for social mobility and Washington Monthly's #1 public institution in New Jersey, Montclair is the state's premier public service institution. Learn more about what makes Montclair a university on the rise at montclair.edu. That's it for this week from the Washington Monthly. I'm Ann Kim, and on behalf of my co-host, Garrett Epps, thank you for listening. If you like what you heard, don't forget to subscribe to our channel or wherever you get your podcasts. Have a wonderful week.